Welcome to The Explainer. Okay, if you're gearing up for the bar, there's one subject that, let's be honest, can feel like a giant wall between you and the courtroom. And that's the law of evidence. But here's the thing. It's not just a subject you have to pass. It's the advocate's playbook. And today, we're going to break down exactly how you can master it. You know, way back in the 18th century, the statesman Edmund Burke made evidence law sound almost, well, ridiculously simple. A parrot can learn it in half an hour? Yeah, right. If only it were that easy. Because in any modern courtroom, evidence is anything but simple. It is complex, it's dynamic, and knowing how to handle it is literally what separates a good argument from a winning one. It's not just part of the game. It is the entire playing field. So, let's open up the playbook. First things first, before we even think about tactics, we have to understand the field we're playing on. What is evidence law really? What's its nature? Okay, the very first thing you've got to get your head around is that evidence law is what we call adjectival. Now, that just means it's not about the substantive rights themselves, like what actually makes up a breach of contract. Instead, it's the rulebook that governs how you prove that breach in court. It's all about the process, the procedure. It's the how-to guide for every single piece of litigation. So it really just boils down to this. Substantive law is the what, the right itself. But adjectival law? That's the how, the actual procedure you use to enforce that right. Your whole case depends on you mastering this how. Because without it, even the most rock-solid legal right is just, it's just an idea on a piece of paper. And look, these rules, they aren't just a bunch of arbitrary hurdles designed to make your life difficult. At their very core, they're the result of generations of legal minds trying to build a system of procedural fairness, a method that's designed to do one thing: find the truth and, hopefully, avoid injustice. Now, for the big one, the single most important principle that underpins everything else we're going to talk about. Seriously, if you only take one thing away from our playbook today, make it this. Relevance. It's the source, the origin, the absolute foundation of everything. Before you even start to worry about hearsay or privilege or any of those other tricky rules of exclusion, you first have to pass this one fundamental test. Is the piece of information you're trying to introduce actually relevant to a fact that's in dispute? If the answer is no, it's not coming in. End of story. So this is absolutely crucial. Once something is relevant, it hits the next hurdle: admissibility. Now, that's a question of law, and it's for the judge to decide. Think of the judge as the gatekeeper. But, and this is a big but, even if the judge lets that evidence in the door, it doesn't mean you've won. The weight of that evidence, how believable it is, how persuasive it is, that's a question of fact for the jury, or for the judge if they're sitting alone. You see, getting it in the door is one thing. Actually convincing the room is a whole other battle. All right, let's get practical. This is where the playbook really comes alive. We're talking about those high-pressure, split-second moments in court that can literally make or break your entire case. The objection. This is not a moment for quiet contemplation. Your opponent asks an improper question, you are on your feet, immediately. Because if you hesitate, if you don't object right away, that point can be lost. And I mean gone forever. And it's not enough to just stand up and yell objection. You have to be ready to argue it right then and there. And when I say fatal, I mean it. The courts have been crystal clear on this. Parties are bound by how their counsel runs the case. The High Court showed this in CTM v. the Queen. Even in a serious criminal trial, if you don't take a point at the first opportunity, you can be prevented from raising it later on appeal. Your silence in that moment can be binding. It's that serious. Okay, another critical moment is when you're trying to introduce evidence after a trial is over, and you have to know the difference between fresh and new evidence. Fresh evidence is stuff you genuinely couldn't have found, even if you tried. New evidence is stuff you could have used, but for whatever reason, you didn't. The court's tests for these are worlds apart, incredibly strict for fresh evidence and almost impossible for new. So why are they so tough? Because the whole system relies on the finality of litigation. So these rules feel ancient and timeless, don't they? But they're not. And to really understand the playbook, you've got to know how it was written. And believe me, its history is surprisingly modern. You might think these rules are ancient wisdom, matured by the wisdom of the ages, as one judge put it way back in 1790, but the truth is, the subject as we actually know it today is barely 2 centuries old. When that judge was saying that, the field was really just getting started. The real action started in the 19th century,
The whole focus shifted from really basic questions like who was even allowed to speak in court to that core principle we talked about, relevance. That happened around the mid-1800s. And here in Australia, our biggest attempt to codify it all, the Evidence Act, didn't happen until 1995. This isn't ancient history. This is a living, breathing, and evolving discipline.
So we come to the final and maybe the most important question. Why is this subject so absolutely vital for every lawyer who's going into litigation, not just the barristers who are on their feet in court? Never, ever let yourself think of evidence as some academic subject you just have to get through for an exam. It is the absolute opposite of academic. It is the practical, hands-on, working toolkit of every single litigator. This is where all that theory smacks into the cold, hard reality of the courtroom. Just think about it for a second. Long before a barrister even sees a brief, a solicitor is out there gathering the facts. If that solicitor doesn't have a deep understanding of relevance and the rules of exclusion, that crucial evidence could be contaminated or worse, lost forever. In trials that are run on affidavits, it's the solicitor who is basically presenting the evidence in chief. And things like legal professional privilege or without prejudice negotiations, these are the everyday tools of the trade for all lawyers. Your job as an advocate starts the second a client walks through your door.
And really, that's the challenge for your generation of advocates. In a world where the rules are constantly evolving and judges have more and more discretion, your mastery of these fundamental principles is more critical than it has ever been. The playbook is in your hands. So the real question is, how are you going to use it to prevent error and to elicit truth?